Hello, it is I, the one who is in some circles called former United States Supreme Court Justice John Paul Stevens. I'm here to talk to you today about the Sixth Amendment of the United States Constitution. Specifically, one-third of that amendment, the part referring to the assistance of counsel for defense. One of the first instances of the right to counsel showing up in American history was around 1770, near the beginning of the American Revolution, when the Boston Massacre occurred. British Captain Thomas Preston and 8 of his men were charged with the murders of 5 civilians during the protests. However, no one in the town wanted to represent them due to everyone in the town at the time hating British people in general because of taxes and in the beginning war. But one man, John Adams, understood the meaning of the right to counsel. He defended the British men, and only 2 of them wound up being convicted. This was one of the earliest mentions of the right to counsel in American history. The next major Sixth Amendment case did not come up until the year 1932 in the state of Alabama, when a group of black men, later known as the Scottsboro Boys, were accused of raping a couple of white women on a train. During their trial, they were given 2 lawyers to comply with the rule giving them their counsel. However, the lawyers were said to be so ineffective that they would have been just as well off not having any counsel at all. After losing appeals on this note all the way up to the Alabama Supreme Court, the United States Supreme Court stepped in and said that they were entitled to fair treatment by counsel involving effective counsel that had to be worthy of helping them do better than they could have done themselves. The first test of this new fairness test came up just 6 years later in 1938 with Johnson v. Zerbst, in which 2 Marines were charged with using counterfeit money. They had enough money at the time to pay for their lawyers before their arraignment. However, they were put in jail before their trial and used up all their money, and by the time they got to their trial, they could no longer afford lawyers. They were forced to represent themselves, as counterfeiting was not a capital crime and thus was not at the time considered required to be provided counsel. The Supreme Court used this case to change the ruling surrounding the right to counsel clause, making it so that in federal courts were required to provide counsel for those that could not afford it themselves, instead of simply being able to provide them with counsel. Betts v. Brady started out as a Florida robbery case in 1942. Betts asked for a lawyer, but the court's judge declined to provide him with one, stating that robbery was not carrying a death sentence and thus did not require one, which was not obligatory in state courts at the time. The Supreme Court, for some reason, decided to agree with that, stating that just because a person could not afford a lawyer did not mean that it was necessarily unfair unless there was some sort of complication in the case or illness or deficiency in the defendant. This remained the case until the famous Gideon v. Wainwright, also from Florida, in 1963. The Florida law at the time claimed, as it did during the time of Betts, that only cases carrying death sentences or those with the aforementioned qualities of the defendants required assistance of counsel. However, Clarence Gideon said that this should not be the case, and in his ruling, Justice Hugo Black agreed, saying that the Sixth Amendment's right to counsel clause did not differentiate between the types of cases it applied to, and thus neither should the application of the amendment's clause. This new requirement led to a lot of cases needing counsel that it had not before, which led to a need for more lawyers to handle more cases. At the time, there was no system for paying these lawyers, so they were forced to do so for free. This remains an issue to the current day, as lawyers are currently consistently overworked and public defenders have not the time to defend all the people that they are charged with, and thus we've seen a rise in settlements of cases, and it's an issue that continues to plague the country today. So that will be the end of it.